Our session at this time is Civil Law 101 and Expanding Intercepts to Assisted Outpatient Treatment, presented by Judge Oscar Kazen. He is the presiding judge of Bexar County Probate Court Number 1, previously served as the Associate Probate Judge for Bexar County Probate Court 1, as well as Judge presiding of Bexar County Court at Law Number 9. Judge Kazen created and oversaw the first fully operational civil assisted outpatient treatment court in Texas, serving as the intersection between the law and treatment of individuals with serious mental illnesses in a 52-county area. This court has served as a national model, saving lives and lessening the suffering of those with serious mental illnesses by offering an alternative to hospitalization. Unfortunately, Dr. Shawna Corley was not able to attend today, but Judge Kazen has asked Erica Von Lowe, a licensed professional counselor currently working as the court liaison for the Center for Healthcare Services and Assisted Outpatient Treatment Program, to join us today. Erica has been licensed as a professional counselor since 2005 and served in many counseling positions across the San Antonio community. Her experience includes working with children, adolescents, families, geriatrics, and adults with a variety of mental health concerns in multiple treatment settings. Judge Kazen.
I have been told that you all are running way behind, and I said, well, I can always cut it short, and sure enough, all I heard was yes. So I'm going to go ahead and cut back a little bit. Many of you have heard me this speech and speak to this issue before, but before we start, I have to give him a hard time. So although you were a former Army veteran, I am proud to say that I am twice the Marine I was 30 years ago. So, all right. So for those of you who have heard my discussion on AOT and mental health, today is kind of an oddball for me. Originally, I had been asked to speak to the kind of civil procedure to get into AOT. Towards the end, though, everybody agreed, Judge, just talk about what mental health, civil versus criminal is, why AOT is so important. We can figure out the rest. So before we even start, I'm going to just give you three sections that just write down these three numbers. Section 571, Section 573, and Section 574 of the Texas Health and Safety Code. And in case you actually have one afternoon with nothing to do but read a small arcane section of law that deals with civil commitment and mental health, because it's what I love, it's well worth the read. It's only about 30 pages, and it is what we do in the civil probate courts. So, for those of you who don't know, I am Judge Kazen. I am the judge presiding in Probate Court Number 1 in Bexar County, Texas. It is a statutory probate court. And again, for those of you who don't know what that is, there are about 18 statutory probate courts in the 10 major jurisdictions. Somewhere along the way, someone had the wisdom to create a court that only did probate. Only we don't only do probate. That court does 5 things. It does probate, matters of guardianship, matters in mental health, which we'll speak to in just a few minutes, matters of trusts, and then for some reason, somewhere way back when they created statutory probate courts, the legislature said, well, we've got eminent domain left over. What do we do with that? Get me a dart. Probate. And we do eminent domain. But of it all, mental health is probably the most important part, at least that I love doing, and guardianship, primarily because guardianship and mental health are about helping people who need help now, helping them in a dark moment, getting them through a difficult spot. And when you think about what a mental health court is in probate, I often tell everyone, and you'll hear it more and more, and for me it's amazing. I've been dealing with specialty courts since 2002, when we first started creating them, even in Bexar County. I was one of the few judges that wanted to do these things. It's amazing to me to watch judges compete over the title of being the mental health judge. And you get that, because there's no definition of the mental health judge. There's no definition of a mental health court. And when somebody goes out of their way and say, I'm the mental health judge and blah, 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 I kind of sit back and it's a good thing. I'm glad that judges are competing now to do mental health. It's a wonderful thing. But the truth is, it isn't in the title. It's in what we do. It's in the lives that we affect as judges. That's what matters. The title does not matter. Whether you are a criminal court that happens to have what they call specialty courts, and you're running a docket of 30, 40, 50, 60 people that you can monitor and get through their probation while they're having mental health crisis, or a statutory probate court such as ours, which we do over, I think, between 2,700 and 3,000 filed mental health cases. We do over 5,000 hearings every year because they all funnel through us in that small part of the law that most people don't understand, civil commitment. That's that section where someone hasn't broken the law. How do we keep them from breaking the law in the future? How do we get them treatment before they are involved in the mental health system and the judicial system? And that's where probate court comes in. So before I get there, I am also privileged enough to have been a former county court at law judge, primarily and almost exclusively having done criminal cases. And I was a criminal defense attorney before that. And I was a family law master. And I was the associate probate judge. But there's a difference. And it's a part of the law that we often don't think of. It's the distinction between an individual who is caught in the criminal justice system and the individual who is mentally ill and caught in just a system. So here's the example. So forgive me for all of my fellow criminal court judges. Anybody with a code of criminal procedure can do criminal law. Actually, I was kind of joking there. But in criminal law, and the difference is, when someone has mental illness, let me go back. In criminal law, when someone winds up in a criminal court, it is typically because they have done something that got them there. As a criminal court judge, once we get past that first question, did you do it or didn't you? Then the second question is, how do I punish you? And in that, we look to each other, we look at the law, we look at the facts, and we decide how to punish you. Sir, I'm going to point at you. You took a car. Sir, in the back, you picked up a gun. Sir, you stole a can of powdered baby food. You see, in a criminal court, once we get past whether you did it or not, then I get to decide. You stole the car, but you did it because you were trying to take your pregnant wife to the hospital. You stole the car, but you did it so you could take it to a chop shop. You picked up the gun because you had no other choice but to defend yourself. You picked up the gun because you wanted to point it to my head and rob me of my wallet. You stole powdered baby food. And you took that powdered baby food because your child was starving. Or you took that powdered baby food to cut your meth. You see the difference? Once, as criminal court judges, we weigh that and then we punish injustice. But in mental illness, in mental health, especially in probate courts, when someone is struck with mental illness, they have no choice. Think about that for a second. It's not as though somebody wakes up one day and says, well, you know what? I heard about that bipolar. I sure would like to try it for a while. I'm really lonely. Some schizophrenia and extra voices would do me good about now. It just doesn't work that way. When it strikes you, your family, your friends, your neighbor, everyone around you. And it is a hand grenade whose shrapnel strikes everyone. And that's why I go back to when we're talking about mental health judges and mental health courts, I don't care. As long as you're helping people who need it. As long as you can keep people either out of the justice system, get them through the justice system, or get them before they get to the justice system. I don't care. We shouldn't care. And given the fact, and I am honored to be one of the commissioners with the Judicial Behavioral Mental Health Committees, or I am. But it is amazing to me, and it's a wonderful thing that we even have it. 10 or 12 years ago, when I first started talking about these things, if I had 6 people in a room, it would be amazing. We have over 1,600 people participating in this conference from all walks of judicial and civil life. And that is a great thing. So, what's a probate court? Here's your technical part of it. How do we do it? Well, in Texas, when someone is mentally ill, obviously if you've committed a crime, we have diversions within the criminal justice system with specialty courts so that if you're on probation, maybe we can get the charges dismissed, maybe we can get you to deferred adjudication, maybe we can get you through probation without getting in trouble if you attend a specialty court that wraps services around you. I'm sure you've heard of those, and I'm sure that's part of the program. But what happens if you haven't broken the law? What happens if you are mentally ill, immediately dangerous or eminently dangerous to self or others? Where do you go? Well, in Texas, the probate courts and the jurisdiction of the probate courts are that intersection between mental health and justice or pre-justice. When somebody gets to the point that they are so ill that they become a danger to self or others, a law enforcement officer can detain an individual. Think about it. In Texas, you can detain an individual basically in one of two ways. They either did something that got them arrested, or their behavior is such that they need to be detained for their safety and the safety of others, which does not include breaking a law. So when an officer sees someone that's immediately dangerous to self or others, and they're mentally ill, and the officer believes that the information they've received or they have seen is credible and reliable, they can take that person to the nearest appropriate mental health facility. That's called a warrantless emergency officer arrest. But the distinction, and it's in different communities, the distinction is that the warrantless arrest requires that the individual or the officer not have time to have sought a warrant from a judge for the same detention. My son is schizophrenic. He believes the neighbors are terrorists. He has not been on his medication for 3 weeks now. And he's been talking about getting a machete and chopping their heads off. Oh my God. Police officers, please show up. Police officers show up. They go talk to my son. My son says, I don't like my neighbors. Are you going to hurt them? No, not at all. I'm not going to hurt them. Nope, not going to do it. Officer looks around. He doesn't see a machete. There isn't something imminent. He may come to me and go, you know what? I think your son is truly ill. There needs to be an intervention. We need to take him somewhere before he hurts someone. But he's not doing anything in front of me. The second way to get them there is to go to a judge. Every judge of probate jurisdiction has the right to execute what's called a judge's mental health warrant. And there is some great division between judges who do that and judges who don't. So there is a thought, and I will be honest with you, amongst judges in Texas, that if in fact the police officers didn't see the issue, didn't see the crisis, they're not going to execute a mental health warrant. However, and I would caution that thought, officers don't have the luxury of waiting. It has to happen right in front of them. If it doesn't, that's when they come to the judge. My son has a machete. He's going to chop the neighbor's head off, and the voices are telling him to do it. How is that not imminent? It may not be immediate, but imminent danger of serious harm to self or others. And the code says that if, in fact, a judge under this particular section finds sufficient cause, they shall execute a warrant. And I caution those who don't do it. It's only a matter of time before somebody gets killed and there's a huge lawsuit. Why didn't you do it? And then they execute it to the nearest police officer. The police officer either takes them on emergency detention or on a warrant to the nearest appropriate mental health facility. Now here, there are kind of two interplays. You've got facilities that have to accept individuals in crisis under EMTALA. That's the Emergency Medical Practices and Labor Act. That requires a hospital to take somebody when they're in crisis, a broken arm or a broken mind. It's the exact same thing. And officers often take them to emergency rooms. And while they're in the emergency room, what happens next is we need to determine if they're going to stay. That's called probable cause. And the hospital gets to keep them for a period, again, if you look at the section, you'll get the exact numbers, but gets to assess them at about 12 hours, gets to keep them for 48 hours. And then they have to ask me whether we're going to keep them any longer. And here's when I'm going to pause and share a funny story with you. You know what the worst thing that could happen to an individual? A recently retired father. My dad, God rest his soul, when he first retired, had nothing better to do than to call me. And when I was a county court of law judge, the conversations would often be, you hang up. No, you hang up first. You hang up. It was every 5 minutes. So he called me one day and said, what are you doing? I said, well, I'm in trial. Well, what kind of trial is it? Well, lo and behold, it's against the law to try to commit somebody, especially your spouse, to a mental health institution in an unwarranted manner. I said, well, Dad, and let me tell you what happened. Some gentleman divorced his wife, went downstairs, filed an application for a mental health warrant, said she was completely distraught, she was going to kill herself, she had tears, she was crying profusely, she needs to be detained now. And the judge found immediate cause, had her detained, had her taken to the hospital. And here's where that intersection comes in. There are safeguards. A doctor looked at her and said, well, there's nothing wrong with you. And she said, of course not. Well, it says here that you were depressed and crying profusely. And she says, those were tears of joy. She got discharged. Well, now he's being prosecuted. Back when I was a county court at law judge, and so Dad asked, what are you doing? I said, well, we got this trial going on where some guy tried to put his wife in an institution for divorcing him. And there was a long pause. And my dad says, there's something wrong with that? My next phone call was to Mom. So anyway, but the system is built so that each time someone does get detained, we have those same types of hearings. We'll have a probable cause hearing, and then we'll have a commitment hearing. That's called an order of protective custody. Now, I've been asked to just kind of touch base on this one subject. Forgive me if I go a little long on this, but there are some jurisdictions that ask for what's called an OPC Acceptance Letter. Those of you who are in the field know that when somebody asks you for forgive me, let me turn that off. I still have a VCR and the 12 o'clock still blinks. All right. So when somebody files for an OPC, there are some jurisdictions where judges will not accept the request for the order of protective custody unless the hospital can first swear and affirm the person has a place to go. I will tell you there is no such provision in the Texas Health and Safety Code for two reasons. One, the Texas Health and Safety Code says that they are to be kept at a facility that is designated by the local mental health authority as the appropriate facility. And what Guy Herman did in Austin, and what many jurisdictions do, and the copy of that letter will be in the materials later, is they had the LMHA look at it. And he said, well, you tell me what's appropriate. And the LMHA designated all the emergency rooms and all the hospitals in the area that were licensed as appropriate facilities. Answer done. Or part two, if a facility must take an individual under an order of protective custody, under emergency detention, forgive me, through EMTALA, they can't let the person go until the crisis is over. But they can't keep the person past 12 hours without asking for an order of protective custody. So they avail themselves of the section that allows them to ask for an order of protective custody. If you read the code, most of those are emergency rooms and almost all of them are private hospitals. The other place that you can send them to is a private hospital. I think the better practice is, at least in the emergency detention portion of it, I think the better practice is to require your LMHA to go ahead and designate those facilities that are and aren't. That's their job. Your job is to sign off on an OPC if the OPC meets criteria. That's it. Where they go after that is up to that facility, period. So my 2 cents on that, that's what they've asked me to speak to people about. Please feel free, we'll talk about that little section later. I know there's a great division between county judges and probate judges about how that works. But the better practice is to get your LMHA to designate the appropriate mental health facility. So we get these individuals, we put them through these hearings, and lo and behold, we find out that they must be kept for a period of a week or two until their final hearing. And their final hearing is one of commitment, where we can commit an individual anywhere up to 45 or 90 days, sometimes up to a year. Then it becomes an issue of where they're going to go. And typically, the way we do it in Bexar County, if you file the OPC, it's your responsibility to take them, period, until you find somebody else to take them. And we're going to commit them back to you, period, until you find somebody else to take them. That's how it works, and it works well. But it is definitely a problem for the facilities. It's not that easy, because in Bexar County, for example, we don't have a county hospital, and it is exceptionally difficult to find sufficient space and bed space for those long-term treatment of individuals. Once they're there, however, because we live in a system of revolving door, what happens? Well, it used to be 30, 60, 90 days. Now it's a few weeks. So on the back end, we have designated and created the Assisted Outpatient Treatment Program. And that's where we take a person who's currently under a court order and modify the order to outpatient. And we say, you can go and you're out if you meet criteria, and we'll talk about that on the back end. If you meet criteria, we'll place you under the watch of the judge. We'll wrap the LMHA, the Local Mental Health Authority, will wrap treatment around you. We visit with them once a week. We'll bring them into court if they're failing. And you would be surprised the number of lives that we've been able to save just by intervening with a judge in a black robe. Billy, why aren't you taking your meds? You know, you keep this up, you're going to deteriorate. You're going to have to go back to a hospital. You really want that? The numbers are astounding across the nation. It is a best practice. And again, we only got 20 minutes to do this, so I would love to get into the detail of further detail of AOT. I'll come back on the back end, but I voluntold Erica to talk a little bit about how she does as our AOT liaison officer, the person actually in the trenches of providing services. So Erica, and then I'll come back in a bit. And I have to apologize. I told him I was giving back time. I lied.
Thank you, Judge Kazen, and thank you for allowing me to be here today to share about the Assisted Outpatient Treatment Program in Bexar County. A little closer to me? Okay. So I'd like to start by telling you what it is that we do. So AOT identifies and provides treatment to individuals with severe mental illness. These are individuals who are in need of a structured outpatient treatment program due to the inability to participate in treatment voluntarily. They can benefit from being on an outpatient civil commitment, and the goal is to help increase treatment compliance, reduce hospitalizations, and/or interventions with the justice system. The treatment that we provide consists of doctor's visits, medication management, intensive case management services, therapeutic justice using the black robe effect, and weekly court case staffings. So now that I've told you what we do, I'm going to tell you how we do it. And the first step in that process is the referral process. And I had a slide here at the very beginning. And this slide represents the point of entries into AOT. So since there's multiple points of entries, referrals for AOT can come from the court, the hospitals, internal programs, external programs, and the community. Let's see where I'm at here. The second step is the screening process, and so an appropriate candidate for AOT is going to have a priority population diagnosis of major depressive disorder, bipolar disorder, schizophrenia, or schizoaffective disorder. They have the need for that structured outpatient treatment program, and that will present as past failed attempts with treatment, multiple hospitalizations, family and community reports, and involvement with the justice system. They'll also have a level of understanding and agreement of their responsibilities to maintain their treatment and have access to stable housing, either their own individual housing or a group home or treatment facility. And if they don't have that, then they'll have the willingness for placement upon discharge from the hospital. An inappropriate candidate presents to us with a primary diagnosis of substance use, borderline intellectual functioning, and the inability to not be influenced by a court order. That inability will present as severity of symptomology, personality structure, or past attempts with the AOT program. The treatment interventions that we have consist of the monthly meetings with the doctor for medication management, assistance applying for benefits, Social Security, food stamps, Medicaid, medication training and education, linking them to any community resources that could benefit them, such as partial hospitalization, counseling services, day programs, crisis management services. We're able to initiate temporary detentions if mental decompensation occurs and the need for a higher level of care emerges. And then we have our weekly court case staffings, where we review their progress, identify needs, and really focus on helping them continue to build relationships with the court staff. So I want to talk just briefly about the black robe effect. Judge Kazen referred to this earlier, but this really is the power tool intervention and at the heart of AOT, and what I see as just the brilliance of the program. The black robe effect is using the influence of a caring judge to promote treatment engagement, compliance, and treatment outcomes. It provides AOT a judge that is knowledgeable on mental illness, that is able to build and establish relationships with our consumers. The judge is able to balance authority with compassion, which creates an opportunity for individuals who are among our most vulnerable and have often been forgotten to be seen, heard, and cared about in a courtroom. This personal connection with a judge really does have far-reaching value and necessary influence. One of the benefits that I've personally been able to see is it become a catalyst for individuals to heal past trauma from previous interactions with law enforcement or court systems that are not equipped to understand their histories, vulnerabilities, past abuse that so many with mental illness have. So I've told you what we do, I've told you how we do it, and I'm going to just leave you with 2 AOT success stories so you understand the reason why we do it. I'm sorry, I lost my place here. Here we go. Okay, so the first candidate was an AOT that was referred by criminal court. This was a female who was in her early 20s. She was facing illegal firearm possession and drug possession. She had a diagnosis of bipolar disorder and a history of abuse and trauma. The criminal court that she was working with identified her as a victim, so we were able to screen her for AOT. She was participating in a partial hospitalization program, and she did that for 30 days. And after she completed that, we were able to place her on the AOT program. She was compliant with treatment and medications and was able to start working. She later became a manager at a restaurant and successfully completed her AOT commitment and the AOT program. She did not have any hospitalizations during that time. She did not have any further interactions with law enforcement during that time. The second individual is an AOT that we had referred from an inpatient hospitalization. This was also a male in his early 20s with a diagnosis of bipolar, and he had a family violence charge. This individual had an initial return he went to our crisis unit, so we had to do a temporary detention. There was mental decompensation. The first week he was out of the hospital, he did not take his medication. At the crisis unit, they were able to make some medication changes, and that point forward, he was compliant with meds, treatment, court staffings. He was able to start working, and he maintained steady work during his commitment. And he successfully completed his commitment, no further hospitalizations. So thank you for allowing me to share this program with you, and I'm going to give it back to Judge Kazen. He's got some closing comments.
That was her first time in front of a large crowd. So when she opened the door, she said, "No." I said, "Yes, you're going in there." All right. So I know it's been rushed. I'm going to pause the next 4 or 5 minutes because I think it's important to note this AOT, assisted outpatient treatment. So as amongst specialty courts, most of us follow a model called the therapeutic courts model. And if you do, it is a combination of both a judge with a treatment team. This is probably the most important sentence, working together to help an individual to stability. If you find yourself in a treatment court with a judge who is angry and upset and pointing a finger all the time, then you should worry. If you find a judge who doesn't pay attention and say, "Well, a caseworker says you're fine," you should worry. It is a dynamic where you take an individual who is currently on commitment and meets a different criteria for outpatient treatment. That is, that they have a history of noncompliance, that they're severely mentally ill, that without treatment or AOT, they will deteriorate. That once you get them from the inpatient commitment criteria, which is they're eminently or immediately dangerous to self or others, serious harm, etc., that once you transfer them over, the jurisdiction of the court continues. And I will tell you that there are many, many judges who do not do AOT as a diversion from criminal court because they find it to be a court without teeth. It's a paperless tiger. And I'm probably one of the few guys that can tell you I've been that criminal court judge where ultimately, if you don't do it, you go to jail, so it's up to you. I'll do it. But on AOT, the success of AOT depends on building trust with the individual that's in front of the court. I don't have that luxury of threatening to revoke your probation. I don't have that luxury of making stipulations to your probation. All I can do is point out to them that if they fail, they go back into that revolving door. They go back to where we got them out of. And if you do AOT correctly, if you take the extra effort to touch somebody's life as a judge, and even divert them from the criminal court systems onto the civil commitment, if they're mentally ill, if they need treatment, et cetera, that it is a much more difficult job. But I will tell you that nationally, and these are proven statistics, it has an 80% reduction in jail, crisis, and hospitalization across the country. If you just have a judge that cares enough to see you every week and say, how do we keep you out of trouble? It could be something as simple as, I lost my driver's license. Oh, I couldn't get to the pharmacy. And I see several people here who started programs who've truly helped individuals with that one question that we as judges can do. How can I help you? It's amazing. I've talked to probation officers through the last 30 years, 20 of them on the bench. And originally, they would come to me and say, I would ask them, are you law enforcement or are you treatment? And for many, many years, probation officers would say, I'm law enforcement. And for many, many years, judges would say, I'm law enforcement. Now I think we are starting to understand with specialty courts and AOT that we can make a difference. I'm going to leave you one last thought. It's a long one. You know what the worst or the most sobering moment for a young judge is 20 years ago? Losing his first re-election. I lost my very first shot at re-election in one of these wave elections by 6 votes. I could have hugged the 6 of you and still been that judge. But the one thing I remember was that we had created this newfangled court that now everybody knows of, the therapeutic drug court in Bexar County. And at the end of my career, the first time, right before I came back right away, yay. At the end of that career, a young man came to the door, pushed the door open, the double doors, while I was on the bench. I was sitting there waiting for my term to expire. And this guy says, Judge, do you remember me? First of all, don't use that term with a judge. It's really scary. All right. So, Judge, do you remember me? And I thought, oh, great. And my bailiff kind of looked over. And then he reached in his pocket. And I thought, what a hell of an end to a horrible year. And he looked up, he says, you don't remember me, but I was one of your very first drug court graduates. This was back in 2000, I think 4 or 5, somewhere in there. He says, you don't remember me, but I was one of your very first drug court graduates. He says, I know you lost, I know it hurts. And this is a crowded room. I had defendants in there. And he tosses something at me. He comes right up to the bar, and he tosses this thing at me, and I caught it. And it took me a moment to realize that they were 24 NAAA chips. And he said, I know it hurts. He said that I'd get a little teary when I think about it. He says, I know it hurts. You'll be back. But I couldn't let you leave without knowing you made a difference. He turned around and walked out. I have kept those chips at my bench for the last ever since I got back on, way back when. I have kept those chips every time I wear that black robe by my side. We used to campaign, "We're tough on crime." Remember that? Go back to the early 2000s and 90s. Good luck getting elected on, "I want to help people through their period." I'm tough on crime, hang 'em high. Remember that? Those days should be gone. And I am damn glad everybody's competing for the title of mental health judge. Be one of those people. Thank you.